The following is an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.
Welcome to Island Justice with Roger Batchelor. Today we have Richard Schwartz, who's a local lawyer. He's a criminal defense lawyer and has a specialty in youth criminal justice. And Richard, I'm going to ask you to start off by telling us a little bit about yourself. How long have you been practicing law for, and why are you interested in youth?
Sure, Roger. I've been practicing law since 1980. I started in Vancouver and came to Victoria in 1982, and I've been practicing criminal law since then.
And why criminal justice for youth?
Well, I got involved in the area of criminal justice in my early years. I worked, as I say, in Vancouver in the criminal justice field, and it was as natural. I enjoyed being in court all the time, enjoyed meeting the clients and helping the clients get through a very difficult point in their lives, and hopefully getting them results that they're happy with.
So things must have really changed since that time in terms of the way we deal with youth, and we have a new youth, or reasonably new Youth Criminal Justice Act. How have you seen the changes take place?
Well, indeed, when I started practicing, the relevant law was the Juvenile Delinquents Act, and that act had been in force in Canada since the early part of the previous century. In the 1900s it was passed. So it wasn't substantially changed until the early 80s when we had the Young Offenders Act. The Young Offenders Act then became the Youth Criminal Justice Act. So I've seen quite a variety of approaches over the years in terms of youth criminal justice.
And what are those approaches? How have things changed?
Well, they've changed a lot, and yet in some ways they haven't changed very much. The legislation has become considerably more formal and process-oriented. Youth have been granted more formal rights to defense counsel, to their charter rights, which we all enjoy. Yet at the same time, the Youth Criminal Justice Court has consistently tried to deal with youth in a way which takes into account the unique characteristics that young people bring to the area of criminal offending, and then dealing with them as young offenders.
Mm-hmm. Now, one of the things I think that people must think is, when I think back to my childhood, for example, and the kinds of things that I did as a youth, which I could have gotten into trouble for.
And which would be for another program.
That's right. If I were to do those kinds of things today, I think the consequences might be different.
Well, I share some of those memories, which would be for another time. But I must say, in the old days, people remember fondly being dealt with in an informal manner by the local constabulary, the local police, who might know you and your family and deal with a matter by way of bringing you home and talking to you in the presence of your parents, or talking to your parents, and letting the consequences be dealt with in the home. Mm-hmm. That's this idea that we have about how things used to be dealt with. I think the reality was a little different, and certainly young people have always been prosecuted formally for their offending. But the introduction then of the Young Offenders Act and then the Youth Criminal Justice Act did formalize the process, and so we are more apt to see police reports that lead to prosecutions in a formal way now, perhaps, than we did under the Juvenile Delinquents Act.
Okay.
Yeah.
And that goes to my next question. The Act has provisions for police, what they call police cautions.
Yes.
And Crown cautions.
Yes. The Act has put into a formal wording, into a formal law, that old process of dealing with things informally. When a young person is charged with a criminal offense, usually a more minor criminal offense, take for instance shoplifting. If the youth has not been charged before, then it's quite typical that they will be able to take advantage of what's called the diversion system, or the system of alternate measures. Mm-hmm. And that recognizes that often for young people who don't have serious criminal issues, and for non-serious matters, or less serious matters, that they can be dealt with without the formal process of the criminal justice system. You take advantage of the involvement of community members and families, victims sometimes, and you deal with it without involving a judge, a prosecutor, a defense lawyer, and all the costs and expenses and rigmarole of that formal system.
Okay. And so how is the police caution different from the Crown caution, for example?
Okay, well, the police caution is, as it suggests, it's a system, it's a response to a youth's offending in the community that originates and finishes at the police station. They have their own process. They may do it informally, they may do it by way of a letter, they may involve a local group of community of citizens who deal with the youth, sometimes bringing the youth and the victim together and working out some form of appropriate response to the offense. That could be a police-based caution. Mm-hmm. If the matter is slightly more serious, then the police would tend to send a report into the local Crown Counsel office, and then the Crown Counsel office as well, following the law in the Youth Criminal Justice Act, they have to consider whether the matter should be dealt with by way of alternate measures. Okay. And a Crown caution is one of the alternate measures. Alternate measures can include, at the low end, a letter of caution to the family and to the youth, bringing to the family and youth's attention the fact that something has happened and letting the family deal with it. That's at the low end. Formal alternative measures can involve serious amounts of community work service, meetings, reconciliation meetings between offender and victim, letters of apology, perhaps taking counseling, that sort of thing to try to ensure that the young person doesn't offend again. And most people, most young people that are charged and who are diverted don't offend again. By far the huge majority of them don't offend again.
And that was something I was very interested about, because if you again think back to the past, I guess my question is, have we just made something more formal that existed in the past in terms of dealing with youth in a way that recognizes that the focus should be on rehabilitation and teaching them lessons rather than punishing them?
Yeah, I could agree with that. I think there are advantages to the somewhat more formal approach. The more formal approach that we have does allow young people to access certain services, counseling services, allows them to access community work service programs, things that perhaps a less formal service or approach wouldn't include. So there are advantages to the more formalized process, but it is really we have to approach it on a case-by-case basis. Some cases warrant more formality than others.
Okay. So if the process ends up in court then, what kinds of options, if the person ends up either being found guilty or pleading guilty, what kinds of options does the judge have?
The judge, under the Youth Criminal Justice Act, has a full range of options. Anything from, at the very lowest end, a reprimand, which is simply, as it sounds, it's a good talking to between the judge and the youth who is there in court before the judge, having pled guilty to the offense. That's at the low end, a talking to. Up from there are discharges, conditional or absolute discharges, which are sentences of probation that don't result in a formal criminal record. Then up from that are probation orders or restitution orders or orders of community work service. Getting to more serious circumstances, there are custody sentences that can be served in the community, and then custody sentences that can be served, that have to be served in custody in a youth jail.
Okay. And what ages does the Act cover?
Well, one has to be over 12 to be charged and less than 18. Once you turn 18, then you're considered an adult in the law.
Okay. Now, in terms of the Act itself, what's the purpose of the Act? Why do we have this Act, and why is there a different Act for youth?
Sure. Young people are not fully mature. That's not just psychological theory or an idea that people have thought up to try to treat young people differently. It's now well established scientifically, medically, that young people's brains are simply still in a state of development during the ages of 12 through 18. Indeed, in fact, some of the research suggests it goes to an older period, that people's brains and levels of maturity are still developing. That aside, everyone recognizes that young people are still developing their sense of maturity, responsibility, their intelligence, and so when they make mistakes and when they're prosecuted in court, it has to be recognized that the consequences for them should reflect that differing level of maturity, intelligence, growth, and that's why we have a different legal regime for young people than we have for adults.
Mm-hmm. Now, what about the more serious crimes, though? I mean, there's been recent crimes in Victoria where you've had youth who've committed murder.
And the Youth Criminal Justice Act fully recognizes that and has provisions in it for young people to be charged as and sentenced as adults. So in serious cases such as murder, manslaughter, aggravated sexual assault, these are the kinds of charges where the Crown often consider prosecuting the young person and seeking an adult sentence.
Okay. Now, if they're a youth, though, for example, 16 years old and have committed murder, and they get an adult sentence, where would they serve that?
Well, if they are less than 18, they are probably going to be serving that sentence in a youth facility. Once they turn 18, then the court can transfer them to an adult facility. Certainly, by the time they're 20 or 21, they must be transferred to an adult facility. So they'll serve their sentence in the facility that's most appropriate given their age.
Okay. But for example, for murder,
yes,
as an example, if they were prosecuted as a youth, there would be a maximum sentence that's considerably less than it would be for an adult.
Yes, it's still a life sentence, but it's a sentence that results in them being eligible for parole at an earlier stage than if they were an adult.
I see. What's the role of parents in all this? I mean, how do parents fit into this act?
Well, parents have to be notified of any prosecution against their child. It's hoped that by notifying the parents will then show up in court and be there as a resource and as a support for the young person in court. Sadly, that is not always the case, and in fact, sadly, many young people who show up in the youth court really don't have parents in their lives. They may have foster parents, they may have other persons who are providing them with room and board, but their parents are sometimes long gone from the picture.
We're just going to take a short break, and we'll be right back with Island Justice.
You're watching an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.
Welcome back to Island Justice with Roger Batchelor. We have Rick Schwartz, who's a criminal justice lawyer, and we've been talking about the Youth Criminal Justice Act. Now, previously I was asking some questions about the more serious crimes, and we talked about the fact that some people or some children or youth may end up serving time after they're 18, I guess it's 18 to 20 in adult facilities. What are the youth facilities like, and why do we need different facilities for the adults and youth?
Well, first of all, the law demands that there be separate facilities for youth. So that's why we have them. Why we've developed it that way is that, of course, young people have entirely different needs than adults when they're in custody. Number one, they have to, under the Schools Act of British Columbia, they have to receive an education. So there's a good classroom at the youth custody facility where they get very good teaching. There's a low student-teacher ratio at that institution, and they are able to complete schooling sometimes while they're in custody and come out with a better education. They also have psychological and spiritual and personal issues that are more associated with young people, and so to have specialists there in the institution who can deal with those issues, that's to everyone's advantage. The hope is that youth jail is not just a crime school. Young people generally who serve time in youth custody come out and commit more crimes. Sometimes it's just the passage of time that results in young people ultimately who are offenders giving up their offending ways. The hope is that they have some positive experiences while in custody so as to try to minimize that. But the reality is that any time they spend in custody, notwithstanding those good facilities and the good efforts of everybody involved with them while they're in custody, the reality is that they are also rubbing shoulders daily with other young offenders, and the talk, the whole influence there among the young offenders is how to do it better and not get caught, frankly. So it's a tricky situation when you put someone in custody with the idea of rehabilitating them and then putting them into regular contact with other young offenders who glamorize and talk about the very offenses that got them there in the first place. So it's a difficult situation.
So it would seem that the probation officers then are important, because if we're trying to keep them out of these facilities, it's the probation officers that are going to be supervising them in the community.
Yeah, absolutely. The emphasis of the Youth Criminal Justice Act, as it was under the Young Offenders Act, the emphasis is on non-custodial responses to crimes where it's at all reasonable. Custody is supposed to be a last resort, only used in cases where the young person really has to be removed from the community for the community's safety or for the young person's safety. It's only in those circumstances where we're supposed to be really sending youth to custody. The language and the practice of the Youth Criminal Justice Act is designed to ensure that less young people go into custody for less serious offenses, but that where there is a serious offense, that you have the ability to crack down on that offender and that offense.
Okay. Now I know with adults, we had a show previously that dealt with this, when there's mental health issues, often the criminal justice system is the net that catches them rather than getting the help they need. How does it work with youth who have mental health problems?
Well, we're again fortunate that under the Youth Criminal Justice Act and through the Ministry for Children and Families associated with it, we have specialized youth psychologists and psychiatrists in a relatively well-resourced environment in the custody center to deal with the young people who are in custody. Those resources are also available to young people who are not in custody but who are on probation. So yeah, there's an emphasis on recognizing those issues and trying to deal with them before they result in more serious offending. But it's well known that there is a concern about whether those resources are sufficient, whether there are enough programs in the community to deal with young people and their issues, whether the people who really have the needs are getting served.
Okay.
It's a real problem.
Now, have we just institutionalized punishment? And by that I mean, when 20 years ago the parents would have been more likely, the school would have been more likely to deal with a lot of the things that are probably going through the Youth Criminal Justice Act? Have we just created another layer of institutionalization to deal with these things?
I wouldn't say so. I think that the criminal justice system for youth is pretty well reserved for cases where it's required. That's my own experience anyway. I see clients who are diverted from the system, who who are dealt with in non-serious or non-custodial manner, who are given many opportunities to avoid the more serious consequences that you're suggesting. My own experience is that largely those resources are being used on the kids who really do require them.
Okay.
Yeah, that's not my concern. I can certainly say that when you go back 20 years ago, the youth crime rate was higher than it is now. The youth incarceration rate was higher. Right now in British Columbia, it's actually a bit of a success story. In BC, the number of youth in custody now, and my statistics aren't right up to date, but the latest figures that I have, which go back to 2009, 2010, those figures suggest that in the province now, there's about 130 or so young people in custody.
That's all?
That's all.
Wow.
When you go back to the early 90s, there was over 500 in custody in the province. It's a tremendous drop. Crime rates generally among young people, particularly in BC, this is not a national statistic, but in BC it has been steadily dropping since the early 90s. When people talk about rising crime rates and rising youth crime, maybe they're talking about Saskatchewan, but they're not talking about British Columbia.
Wow. So then, if we're having more children or youth in the community, how are we supervising them?
Well, the ones that are subject to the Youth Criminal Justice Act sentences are being supervised by probation officers who are sorely pressed. They have high caseloads relative to the number of probation officers that there are. There are also youth care workers. There are other individuals working with other agencies, sometimes non-governmental agencies, that work with young people. So there's a variety of ways of supervising the young people in the community, as well as, of course, the ones that are attending school are subject to the supervisions there, the ones who are playing on sports teams and taking advantage of other opportunities in the community. It's a wide range, obviously, of supervisory kinds of experiences for young people. But when it comes to the responses of the criminal justice system itself, there's probation officers and other court-appointed people who are there to assist.
So in your job as counsel, defense counsel, when you have someone who's either been found guilty or pled guilty and you're talking to the judge, what kinds of things are you going to focus on?
That's a really good question, because one of the main focuses that I try to bring the attention of the judge to are those issues of the youth's formative background, to try to help explain why that young person is before the judge at that time, having committed that particular offense. And sadly, many of my clients come from backgrounds which you don't want to think about. They're sad, they're tragic. Many of them experience violence to themselves. They experience violence within their families. They witness violence within their families and outside in the community. Many of them suffer from deficits such as fetal alcohol syndrome, fetal alcohol spectrum disorder. Many of them suffer from attention deficit hyperactivity disorder, which is a real thing. It is a real thing. And so their ability to succeed at the kinds of things that give young people generally a sense of accomplishment and a sense of well-being, their ability to succeed is just not the same as you know, your children or mine, and thankfully. And those are the issues that I always try to ensure the judge understands when dealing with the young person. So often the young person is in court because of circumstances beyond their control.
Mm-hmm. So one of the questions I always ask in the show is to talk about an interesting case that you've had.
Well, you know, lawyers are, of course, under an obligation to not divulge the confidences of their clients. So I don't want to get too specific, but I think the interesting thing about working with young people in the criminal justice system is, and again, we get back to this last point, is the sad array of backgrounds that contribute to the criminal justice problem, and the efforts that are being made to try to deal with them. A lot of people are trying hard, putting in a lot of time and effort, a lot of resources to try to assist young people who are in these situations, and it's always interesting to see the successes. They're not.
And that's what I was going to ask you about next.
Yeah, well, the successes are the ones who you lose touch with because they're not coming back to court. And it's always terrific to run into someone on the street who remembers you as their counsel and who is thankful for the help that they got and is as proud as can be of the job they've got, the child they've had, the family that they've now got, and how things have improved in their life. And that's what I think is interesting.
So if you could change one thing in the Youth Criminal Justice Act, what would you change? Well,
I just think we have to stop producing children with the deficits that some of these kids are being born with. Fetal alcohol syndrome is a continuing problem, and kids born with that syndrome and who are then raised in families that are challenged in that way in terms of substance abuse, and it's not just alcohol but narcotics of various sorts. If I could wave a magic wand and eliminate those kinds of situations, those kinds of births, we'd have a much healthier community.
Well, thank you very much for joining us today. You've been watching Island Justice with Roger Batchelor. We've had Rick Schwartz, who's a criminal defense counsel for youth, and thank you for watching.
The proceeding was an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.